Let's go.
Clauses 1 to 3.
The question is that clauses 1 to 3 stand part of the bill. The question is that clauses 1 to 3 now stand part of the bill. Those in favor say aye. Any against? The ayes have it. Clauses 1 to 3 now stand part of the bill.
Clause 4.
The question is that clause 4 as amended stand part of the bill. Minister.
Thank you very much, Mr. Chair. Mr. Chair, we have a simple amendment here, and it's just to create a definition of what electronic versions of the law mean. And for the record, the amendment is that electronic version of the law means a written law that is published in accordance with Section 5A, subsection 2.
Mr. Speaker, we had a very brief opportunity to take a look at the proposed amendments and to have some brief discussions with the government side. And this particular proposed amendment actually ties up the point that was being made during the debate, where there's a specific definition of laws that would not have included the electronic version. Yes. So I'm happy to see this.
Clause 4 be amended as circulated. Those in favor say aye. Any against? The ayes have it. Clause 4 as be amended as is per the circulation now stand part of the bill. Huh? Members, the question is that clause 4 as amended now stand part of the bill. Those in favor say aye. Those against, no. The ayes have it. Clause 4 as amended now stands part of the bill.
Clause 5.
The question is that clause 5 stand part of the bill. Minister?
Mr. Chair, we have two amendments to clause 5. The first amendment being that at clause 5A, subsection 3, subsection B, insert after the word PDF the words or such other approved format, and that would also be consistent with the amendment as being proposed in 5A2, because the minister can have the power by order to approve any other format other than PDF. So when we looked at 5A3, we also included it to be any other format after the word PDF.
Mr. Chair, again, if one were following the debate, this is something that we drew reference to, so I'm quite pleased to see this. By the addition of the words or such other approved format, what it does is, without even the need for the order, it gives the minister the opportunity to cover the bases as technology becomes more available. So we're in agreement with that.
And Mr. Chair, the second amendment is 5C. 5C deals with the change or correction. What we have done is that we have removed the word change because of the editorial changes that can be made. It would mean that every single time where the powers of law, if they exercise their power for minor changes and so on, which they're allowed to do, it has to be published. So we are suggesting that it only be restricted to corrections of the actual law, and we have removed the word written law and included electronic versions of a law, as this subsection deals specifically with only the electronic versions of a law.
Mr. Speaker,
how does this address the issue of an error in the published version?
In the published version, you mean written or?
The electronically published version. The issue of you are saying that what is published shall prevail, and suppose there's an error in what is published electronically.
Right. So what happens, the minister, there will be, every time a correction is made, there will be a notice being published. And when I explained, when I wound up the debate, there will be stamps to say that the law is this at this date. So therefore,
correct.
That is the
so
version
I
that
got
will
that part.
prevail.
So that takes you part of the way. But suppose what is published at this date electronically is
Yes.
inaccurate.
Well, what happens is that the commission, before they even reach at that stage, even if there's a correction, they will have to publish a notice. So the notice will be made public to show the change.
No, I am only, sorry, I'm taking the opportunity in terms of amendments to deal with an issue in 5, where you say that what is published electronically will prevail. Okay? What
If I may,
happens- Sorry,
the
go
minister
ahead.
for the, the member for the Gomartin Northeast is actually referring to clause 5B as proposed. The electronic version of the laws shall prevail over the laws. That's what he's referring to.
What I'm saying is that if there's a mistake in that, how does this deal with that? Because this is post facto.
So, Minister, even in the written versions, right, if you look at Section 21 of the Parent Act also, in the written version, that can also happen.
Correct.
That the printed version, not written, let me say printed version, can have errors.
Correct.
And those notices are done ex post facto also.
Correct,
So it's
correct.
just a consistency here with respect to that. Because the official version of the law currently, even with an error, is the printed version. And the corrections comes ex post facto, which is the same thing that we're proposing here in terms of a consistency. So if there's an error on the publication of the online version, we now have a power here
To correct.
specific. Yes, to
I
correct.
saw that. But
Just
let's
for the-
I got that. But before it is corrected, someone may avail themselves of what is electronically published and use that in litigation.
Yeah. Well, what we're doing here is no change in terms of the current law as it appears for printed versions of the law. It's just making it consistent with the online versions of the law. Yes. And we support this amendment.
I turn it off, yeah. Yeah, but Minister, is there a way to deal with that? Because if somebody is dealing with a matter in court and they quote the inaccurate version of the law and they use an inaccurate version of the law, what will happen?
I think the amendment will capture it, Member.
Okay, this appears to me to be after the fact, but that's okay.
Clause 5 be amended as circulated. The question is that clause 5 be amended as circulated. Those in favor say aye. Those against, no. The ayes have it. Question is that clause 5 as amended. Honourable members, the question is that clause 5 as amended now stand part of the bill. Those in favor say aye. Those against, no. The ayes have it. Clause 5 as amended now stand part of the bill. No amendments to clause 6.
Clause 6. Yeah, we do after.
Question is that clause 6 now stand part of the bill. Question is that clause 6 now stand part of the bill. Those in favor say aye. Those against,
Mr.
no.
Chairman, I have a question.
Yes.
You say this section shall not apply to an electronic version of the laws.
That's a new one. So
Yeah. Not me. Not I.
Clause. That's a new
I'm
clause.
dealing with this. In this amendment, you say this section shall not apply to an electronic version of the laws. You want to explain?
That should be new clause 7. So we're confirming clause 6, and then we'll go to second reading of new clause 7. That should be new clause 7. Yes.
But it's amending 6, not so?
It's amending the parent 6.
Yeah, I'm looking at the Parent Act right now.
Yes. But if you watch the bill only goes up to clause 6.
No, I got that.
Yes.
So I'm dealing with the effect of this amendment.
Yes. We didn't reach there as yet. I think the speaker has put the question.
All right, okay.
Question is that clause 6 now stand part of the bill. Those in favor say aye. Any against? The ayes have it. Clause 6 now stands part of the bill. Very new clause here. Huh?
Section 6 amended.
This is it. Which one? New clause 6. New clause 6?
Yeah, section 6 amended.
The question is that new clause Shall we say 7? The question is that new clause 7 be read a second time. Those in favor say aye. Any against? The ayes have it. The clause will now be read a second time.
Just for the record, Mr. Speaker, I'll read the amendments into the record. The Act is amended in Section 6 by inserting after subsection 3 the following subsection. Subsection 4. This section shall not apply to an electronic version of the laws. What this amendment simply does, Mr. Speaker, is because of the archaic existing Parent Act, it actually talks about the inclusion and removal of physical pages from the laws. So what we're doing here, Mr. Speaker, is that we make it explicitly clear that this section does not apply to the online versions because it simply doesn't.
Yeah, but I have a question on that.
Sure.
Yes, in 6.3, it speaks about overleaf. So it, clearly it's talking about a paper thing. But in 1, it's not clear. Wouldn't a PDF has electronic pages in it?
Yes, but you remember, Minister, based on clause 5A, B, the new ones in the bill, 5A, B, C, the new laws will be published electronically on a website. The other powers of the Commission in terms of what we just dealt with in terms of corrections, in terms of any amendments, as in the existing law, will appear electronically. This section talks about actually removing the physical pages from the binders to make it the official version of the law, and that cannot apply to the electronic version.
I got that. But it's in PDF form, and a PDF is comprised of pages. So are you saying that this, which speaks to pages and does not in every subsection speak to physical pages, will not apply to the pages in the PDF?
The 5C that we just passed will cover that issue that you're talking about.
All right. Okay, if you say so.
No, after this. Yeah. For the question? Labeled is new clause 7, right? Minister? This has been labeled new clause 7.
New clause 7, section 6 amended.
The question is that new clause 7 be added to the bill. Those in favor say aye. Aye. Any against? The ayes have it. The clause will now be added to the bill. Right. The question is that new clause 7 stand part of the bill. Those in favor say aye. Any against? The ayes have it. New clause 7 now stands part of the bill. Here we go. New clause 8.
New clause 8, section 16 amended.
The question is that new clause 8 be read a second time. Those in favor say aye. Aye. Those against, no. The ayes have it. New clause 8 will now be read a second time. Minister?
Mr. Chair, what we're doing here for the record is that Section 16 is now being amended to say Section 16 of the Act is amended in the chapeau by inserting after the word 9 the words or the preparation of an electronic version of the laws. At Section 16 of the Parent Act, this gives the Commission several statutory powers in relation to printed versions of the law. What we're doing is just giving the Commission, out of an abundance of caution, the exact same powers for electronic versions of the law. That's the simple amendment, Mr. Chair.
Where we are.
New clause 8, section 16 amended.
The question is that new clause 8 be added to the bill. Those in favor say aye. Aye. Those against, no. The ayes have it. New clause 8 will be now added to the bill. The question is that new clause 8 stand part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. New clause 8 now stand part of the bill. Right. Honourable members, the question is that the bill, as amended, be now reported to the House. Those in favor say aye. Aye. Those against, no. The ayes have it. The bill, as amended, will now be reported to the House. Okay, what is mine? All this is mine. Minister of Land and Legal Affairs.
Mr. Speaker, I wish to report that the Law Revision Amendment Bill 2026 was considered in the Committee of the Whole and approved with amendments. I now beg to move that the House agree with the committee's report.
Honourable members, the question is that this House agree with the committee's report on the Law Revision Amendment Bill 2026. Those in favour say aye. Aye. Those against, no. The ayes have it. Land and Legal Affairs. Minister of Land and Legal Affairs.
Mr. Speaker, I beg to move that a bill entitled An Act to amend the Law Revision Act, Chapter 303, be now read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Amend the Law Revision Act, Chapter 303, be now read a third time and passed. Those in favour say aye. Aye. Any against? Division having been called for. As I've said, I have no discretion.
Mr. Padarat,
Yes.
Mrs. Prasad Bisasa SC,
Yes.
Mr. Tanko,
Yes.
Ms. John,
Yes.
Dr. Munilal,
Yes.
Mr. Lee,
Yes.
Mr. Hussain,
Yes.
Ms. Amin,
Yes.
Mr. Alexander,
Yes.
Mr. Miraj,
Yes.
Ms. Mohit,
Yes.
Mr. Sturge,
Yes.
Dr. Bodo,
Yes.
Dr. Dowlat,
Yes.
Dr. Ali,
Yes.
Mr. Morris,
Yes.
Mr. Watts,
Yes.
Dr. Sitaran,
Yes.
Mr. Kesar,
Yes.
Mr. Elder,
Yes.
Ms. Sam,
Yes.
Mr. Narang Singh,
Yes.
Dr. Rup Narang,
Yes.
Dr. Gosain,
Yes.
Mr. Thomas,
Yes.
Mr. Sampson,
Yes.
Mr. Gonzalez,
Yes.
Mrs. Beckles Robinson,
Yes.
Mr. Imbert,
Yeah.
Dr. Gatsby Dolly,
Yes.
Mr. Young,
Yes.
Mr. Scotland,
Aye.
Mrs. Robinson Regis,
Aye.
Mr. Dino Brega,
Aye.
Mr. Manning,
Yes.
Mr. Marcel,
Aye.
Mr. Devines,
Yes.
Mr. Birchwood,
Yes.
Mr. Romaine,
Yes.
Mr. Speaker, the result of the division, 59 members voted for, 0 against, and 0 abstentions.
Honorable members, the results of the division are 39 members voted for in favor of the bill, there's 0 voted against, and there were 0 abstentions.
A bill entitled An Act to Amend the Law Revision Act, Chapter 303.
Very much. Minister of Justice.
Thank you, Mr. Speaker. It is my privilege to pilot the Civil Division Bill 2026 before this Honorable House. Mr. Speaker, this bill was debated and passed in the Senate with amendments on February 10th, 2026. And it is indeed a good time for this House, for this country, Mr. Speaker. The Honorable Prime Minister gave a review and a report on her travels to the United States of America and has brought back hope and optimism for this country, Mr. Speaker. Mr. Speaker, the phones are ringing off the hook. The Prime Minister's phone is ringing off the hook. The Minister of Energy phone is ringing off the hook. Everybody wants to come to Trinidad and Tobago. Everybody wants to participate in this new initiative, and everybody wants to be here. It is indeed a glorious time for Trinidad and Tobago. And no small measure, Mr. Speaker, due to the efforts of the Honorable Prime Minister of Trinidad and Tobago and the decisions she has taken. We have help on all fronts, help in the energy sector, help in national security, and generally help all over. It is indeed a beautiful, buoyant time, and I hope the opposition recognizes that and give praise where praise is due.
Point of order, 48-1. I think the member might be on the wrong bill.
Short answer. Member, are you laying your foundation?
Yes, please. I know, Mr. Speaker,
as Porter Spain South knows, he never delivers
Mr.
his knockout
Speaker.
blow. Context is everything. Civil Division Bill. You want me to explain to you all? Civil Division Bill is about setting up a civil court. Why do you set up a specific division? It is because there's a need to arise for a specific division.
them. Good news troubles them. It is good news.
They are not patriots, they don't like you.
Let's be patriotic for one time, Lopino. Mr. Speaker, on the heels of that, we have a very progressive piece of legislation brought by my colleague, Minister of Land, MP for Sawa Barataria. And today, another piece of progressive legislation is being brought, Mr. Speaker. Mr. Speaker, I beg to move that a bill entitled An Act to Make Jurisdiction for Matters of a Civil Nature exercisable in a division of the judiciary to be known as the civil division, and to make jurisdiction for specified civil matters exercisable in a subdivision of the civil division known as the civil court, to make jurisdiction for small valued claims exercisable in a subdivision of the civil division to be known as the small claims court, to make jurisdiction for estates administration business exercisable in a subdivision of the civil division known as the Estates Administration Office, and for related matters, to be now read a second time. Mr. Speaker, this bill has a little history, and I will just point it out for the benefit of all and the national public. In 2020, June, Cabinet approved the establishment of the Civil Division Administration Department, which had been operational alongside the Court of Appeal, the Civil High Court, the Probate Registry, and the Petty Civil Court, paving the way for this anticipated small claims court. Mr. Speaker, on the 9th of November 2021, a cabinet note was passed. In 2023, 11th of October 2023, a cabinet minute was developed. On the 20th of the 9th, 2024, this bill was passed in this House. It was lapsed as the Senate, it lapsed in the Senate in 2025. So, Mr. Speaker, this is a bill that has some 6 years in making. 6 years in making, and we are here today. The reason why I say it's a progressive piece of legislation, Mr. Speaker, this was initiated by the judiciary in its move to modernize its operations. And it follows, Mr. Speaker, on similar legislation establishing divisions of the court, the Family and Children Division Court Act 2016, the Criminal Division and District Criminal and Traffic Court 2018. Mr. Speaker, the judiciary proposed that the civil division should be created formally by statute, with a civil court, a small claims court, and estates administration office. Mr. Speaker, this does not come lightly. It followed on a small claims court concept document in 2021 developed by the judiciary. If we turn to the small claims court, Mr. Speaker, we are operating under a bit of legislation known as the Petty Civil Court, which was established in 2011. That's how far back we go, Mr. Speaker, 2011, and operating in a system which is archaic, which is not suited for purpose, and it's not delivering justice to the people of Trinidad and Tobago. The Petty Civil Court, Mr. Speaker, deals with matters such as debts, damages, breach of contract, negligence, recovery of the land. Mr. Speaker, when the judiciary did a review of this Petty Civil Court, what they found, Mr. Speaker, was that the average time for disposition of cases took upwards of 2 years. And you have matters under 50,000, people with claims of 10,000, 20,000, 25,000, and you're taking upwards of 2 years. A large part of the problem, Mr. Speaker, which the judiciary found, was that service of process and issues experienced with performing this function contributed to a significant bottleneck. Those of us who started practice many years ago, I know my friend from St. Anne's West, Port of Spain South. Well, I mean, these guys deal with big cases, so maybe they didn't start in a small area. I started at, Mr. Speaker, San Fernando, petty civil court. You would go to the court and you have long lines. You have to wait in time. I know Port of Spain South, he deals with very, very heavy matters, Mr. Speaker. And you line up there with litigants, you wait hours, matters are generally adjourned, frustration, you cannot get service, police cannot serve, bailiffs cannot serve matters, and the court just adjourns matter routinely. Not because they don't want to do it, it's just that the system is so bad. So, Mr. Speaker, it was decided after all this time to create something called a small claims court. There was also, Mr. Speaker, the lack of a dedicated and consistent administrative process to deal with this petty civil court. And, Mr. Speaker, the work that the judiciary relied on, Mr. Speaker, was a World Bank report which talked about the importance of creating small claims court, as distinct from the petty civil, which is attached to the summary court, which is attached to the magistrate's court. You have shared facilities in one building. So they are saying, create a small claims court. You have large amounts of claims coming in, and people are frustrated, smaller parts of the population, where you can dedicate a judge, you can dedicate process servers, you can dedicate technology to make sure that fast-tracked procedures are put in place to make the small claims court functional. It is also designed to make it speedy, to make it less formal, and to introduce certain modern techniques and problem solving in the judiciary. I will give you some stats, Mr. Speaker. For example, during the law term 2023 to 2024, a total of 901 new matters were filed, petty civil court. 830 matters were determined with a clearance rate of 92. But, Mr. Speaker, 5,847 matters remain pending. Mr. Speaker, the judiciary is of the view that this time has come to modernize the system with the enactment of this legislation. They did not take their job, they took their job, I should put it another way, very seriously. They had stakeholder consultation. So that when we reached here with this bit of legislation, Mr. Speaker, it was not fly-by-night legislation. During the period December 2020 to February 2021, the judiciary had their stakeholder engagement exercise, and it was conducted even through the COVID-19 pandemic. The following stakeholders, Mr. Speaker, were engaged: the Law Association of Trinidad and Tobago, the Attorney General and Legal Affairs, Legal Aid and Advisory Committee. In terms of academia, the Hewarding Law School, Faculty of Law, and other institutions who provide degrees or facilities to get degrees outside of Hewarding Law School. You had mediators. You had the National Mediation Board, the Conflict Resolution and Mediation Center of Trinidad, Dispute Resolution Center, Ministry of Sport, Mediate It Limited, and other mediation agencies. You had discussions with the Bankers Association, ATIC, Credit Bureau, Agricultural Development Bank, other banks, ANSA Merchant Bank, and others. Large business entities were engaged, AmCham, TTMA, and many chambers of commerce throughout Trinidad and Tobago. State agencies from Ministry of Labor, Ministry of Trade, Ministry of Finance, Division of Finance and Micro Enterprise Tobago, NETCO, and others. Small Business Owners, Trinidad Contractors Association. So they all came together and they said, listen, how do we progress our small claims? How do we get it moving faster? Based on those stakeholder engagements, this bill came to fruition. Mr. Speaker, the bill contains certain modern approaches to dealing with litigation. For example, you have technological solutions including virtual courts, e-filing, e-payments, and an online dispute resolution platform. Now, Mr. Speaker, why is this important? This is important, Mr. Speaker, when you have an online dispute resolution system. It means that the parties do not necessarily have to be there in person. They can talk to each other, and I think it's called synchronous, where all the parties together are talking at the same time and in a shared space, trying to resolve their matters. Or it can be done asynchronous, where post the event they can communicate with each other, and it is the hope that dispute over small claims may be dispensed with quickly, fairly, and affordably. That is not present right now within the petty civil court system. Petty civil court system, Mr. Speaker, is a very formal system. You have attorneys present on both sides. You have a judge, petty civil court judge, and the matter is very formal. This online system will allow a more innovative tribunal integrated into our justice system. That, Mr. Speaker, is a very forward-thinking part of this. Now, you can also participate by video link and other technological measures, which is not available right now, so that people in far-off parts of Trinidad and Tobago who may not necessarily have the resources to get to the court can participate in this. Now, Mr. Speaker, one of the recommendations of that World Bank report was to ensure the availability of legal aid and the provision of fee waivers for small litigants. It was my honor and privilege this morning, Mr. Speaker, to participate in an exercise with the Legal Aid and Advisory Committee, where the Legal Aid and Advisory Committee, for the first time, under this government, under the jurisdiction of the Ministry of Justice, created mobile units. First time in the history of Trinidad and Tobago. So, the purpose of this mobile units, Mr. Speaker, is that we are taking legal services to the far-flung corners of Trinidad and Tobago. The legal aid, Mr. Speaker, has seen a significant increase in persons accessing legal advice in its offices throughout the country, with thousands of citizens seeking assistance annually through in-person visits, telephone consultations, email correspondence, and web chat services. During the reporting period, September last year, hundreds of individuals access assistance digitally, including over 700 email inquiries and more than 2,000 web chat interactions, demonstrating the public's reliance on multiple channels to seek legal advice. So not only, Mr. Speaker, are we modernizing the law revision, we are modernizing and we are creating a small claims court, and we are ensuring access to justice, access to courts for all the citizens of Trinidad and Tobago. Because, as the Honorable Prime Minister has said, and we have said on the campaign trail, access to justice should not be limited by geography, financial constraints, or lack of information. We are coming to you. And Mr. Speaker, I want to tell the residents of a place, Mr. Speaker, called Cedrus. Cedrus. It will be the first place where this mobile unit will be moving into next week. I am not seeing my arrow here, but I want to tell my arrow, the next week it will be my arrow. And I see my colleague, Mr. Sturge, smiling because he knows the gift is coming to him on the following week, Mr. Speaker. We who represent country areas, rural areas, underserved communities, Kumuto will be guided the following week. We are saying to all the citizens of Trinidad and Tobago, we are coming to you. Any little problem that you have, that you're afraid, you can't afford a lawyer, you are frightened, we are coming to you. We are bringing the mobile unit, we're rolling it into town, staffed by lawyers, staffed by supplementary staff, auxiliary staff, and we'll be helping you solve the problems. Brothers and sisters, what a great day for Trinidad and Tobago. I'm offering my friends on the other side if you are interested. No, please reach out to the legal aid. We would most happily help all of you. I don't know why Port of Spain South is available too for Port of Spain South. You don't have to look so serious. So, Mr. Speaker, I am saying juxtaposing in the passing of this small claims court is this development with the legal aid, with our provision of all the laws for people to read in Trinidad and Tobago from the Ministry of Land and Legal Affairs. Now, Mr. Speaker, this small claims court we are trying to make it as informal as possible. Because, you know, sometimes, Mr. Speaker, when people have the formality, they tend to get a little frightened. I would just like to read from the judiciary document, Mr. Speaker, that we must rethink what constitutes a court and what modern-day delivery of justice demands that are required. It is recognized that the courtroom itself and the hearing are no longer the focal points of a dispute, and instead dispute resolution should be prioritized at an early stage, and only the most complex and difficult cases should end up in trial. We who are in the profession, Mr. Speaker, we know about that. So it is inbuilt into the Act itself, that Section 25, that the matters can and should be referred to mediation at a very early stage. When you put matters into the mediation, the heat cools down, parties are able to think rationally, and sometimes you might not get 100% of what you want, but generally parties come together, they put their head together, and matters are taken off the list. And that is what we want to do. It clears the judicial system, it clears the smaller claims court, and when disputes are resolved, Mr. Speaker, people in the country are happier. They go about their business, they patch their differences, neighbors get back together, people start talking again, and you don't have this long time friction developing between a community. So this government, Mr. Speaker, is geared to making people happy. We're making people happy, everybody. All our measures that we are taking, Mr. Speaker, is to benefit all of Trinidad and Tobago. Everybody in Trinidad and Tobago. Now, Mr. Speaker, not only are we creating a small claims court, we are establishing the Estates Administration subdivision of the Civil Division. Mr. Speaker, between 2023 and 2024, a total of 4,614 new matters were filed. 2,501 matters were determined with a clearance rate of 54%. However, a total of 15,186 matters remained pending. The Honorable Chief Justice Ivor Archie, in his speech on the 2025-2026 term, of the opening of the term, he reported that the probate registry, the Estates Administration Office, formerly known as the probate registry, as a result of the backlog reduction project undertaken in the last quarter of 2024, dispatched 5,370 grants, more than double the 2012 issued in 2023. Reflecting a 105.6% increase in clearance rates. During this period, it completed over 13,000 searches, processed 11,000 filings, and supported thousands of applicants more effectively. Mr. Speaker, the Probate Registry e-Services platform allows applicants to track filings, receive real-time updates, improving communication and reducing uncertainty throughout the process. The EOO, the Estates Administration Office, established administratively, is already making significant impact in the administration of estates. So, Mr. Speaker, whilst it is there administratively, we are now creating, by statute, a division of the Supreme Court, of the Civil Court, known as the EAO. Mr. Speaker, this will be staffed with specialized staff, so they are not all over the place, dedicated staff to this. And it will make amendments to the Wills and Probate Act, and the procedural and technological changes are already in place. And we are going to resource it more fully, together in partnership with the judiciary, to close the gap with everybody. You know, Mr. Speaker, many years ago, we know people complaining about the probate taking long, 3 years, 4 years, 5 years, frustrated. Sometimes people die and they don't get their estates probated yet. We're trying to ensure, Mr. Speaker, that all of these things are closed. Now, Mr. Speaker, there are certain consequential amendments which will happen to the Bailiffs Act, the Summary Courts Act, the the Criminal Division and District Criminal and Traffic Courts Act 2018. Now, if we can deal with certain clauses within the bill, Mr. Speaker, as I indicated, Part 1 of the bill addresses preliminary matters, mainly the interpretation section to define certain terms used in the bill, and references on any written law to civil matters, small claim matters, and estate administration. And if you look at the bill, Mr. Speaker, you would note that it follows the pattern of most bills, but just giving you the breakdown, Mr. Speaker. Part 2 of the bill establishes a civil division of the court comprising a civil court, a small claims court, and the estate administration office, so that the civil division will now encompass those three parts: civil division, small claims court, estates. And that is simplification, allocation of resources, all dedicated towards efficiency. Mr. Speaker, Part 3 of the bill proposes the establishment of the civil court to exercise authority and jurisdiction in civil matters that are exercisable by the High Court at present. The civil court will have the power to hear election petitions. Mr. Speaker, you remember the debacle in 2002-2003 with the cases of Gypsy and Chaitan, where there were not rules and the election court was struggling to deal with those matters. We are now saying that the civil court will have power to deal with these election petitions. The Honorable Chief Justice would be empowered to provide for the times and manner of sittings of the civil court and the assignment of puisne judges and masters. Clauses 10 and 11 of the bill provides for the authority, jurisdiction, rights, privileges, and immunities of civil court judges. Part 4 of the bill seeks to establish the Small Claims Court to have jurisdiction in the respect of small claims and small claims matter that do not exceed the pecuniary jurisdiction of the court. Mr. Speaker, Clause 40 of the bill provides for the pecuniary jurisdiction of court to be prescribed by the Rules Committee of the Supreme Court. Now, the reason why that is done, Mr. Speaker, is if you embed it within the Act itself, anytime you have to make that change, you would have to come back to Parliament to make the amendments. The Rules Committee of the Supreme Court, Mr. Speaker, would have the jurisdiction to amend those rules from time to time easier and to make more flexibility in dealing with these matters. Now, Mr. Speaker, Clause 14.4 empowers the Small Claims Court to grant equitable relief that was expressly prohibited under Section 15 of the Petty Civil Court Act. Equitable relief, Mr. Speaker, you want to go for injunctions? You cannot go in the Petty Civil Court. So the High Court is burdened by a lot of these actions. In certain instances now, you can access this court for equitable claims. It will not have jurisdiction for libel, slander, or malicious prosecution. Part 4 of the Act provides for the Honorable Chief Justice to assign magistrates as small claims court judges, giving added responsibility. The Chief Justice would be able to assign senior magistracy, registrars, and clerks of the courts as ex officio justices of the peace and commissioner of affidavits. The functions and duties of the senior magistracy, registrar, and clerk of the courts are set out in Clause 22. Clause 23 provides for the other members of staff of a small claims court. Importantly, Clause 25, as I already indicated, provides for the small claims court to refer matters to mediation, alternative dispute resolution. We are hoping that at least 50 to 75 matters filed in the small claims court can be determined with this mediation. And whilst I'm on that, Mr. Speaker, within the High Court, the Supreme Court, this government will be engaging and collaborating with the judiciary to try to make mediation as a more mandatory part of the adjudicative process. There was a pilot project conducted in 2014-2015 which showed that mediation and ADR, if implemented at the High Court level, will produce greater results in the determination of matters. So we want to engage the Supreme Court, the Chief Justice, with making that a mandatory provision. Mr. Speaker, Part 6 of the bill provides for the Civil Division Administration Department, comprising a central coordinating unit, the Civil Court Administrative Office, the Estates Administration Administrative Office. And Part 7 of the bill provides for miscellaneous matters, including the oath of secrecy for members of staff, the power of the Rules Committee of the Supreme Court to make rules to give effect to the Act, transitional provisions, and consequential amendments. And the Petty Civil Court, as we know it, would be repealed. So you have certain transition provisions, because there are matters filed in the Petty Civil Court. As we progress on to this, what happens to those matters? We also contain certain consequential amendments to the Bailiff Act, Chapter 461. The consequential amendments to the Bailiff Act, Chapter 461, seeks to reenact Sections 46, 47, 48, and 49 of the Petty Civil Court Act, which will be repealed, as new sections 9A, 9B, 9C, and 9D, respectively. The consequential amendments seek to modernize and redirect bailiff-related procedures so that they operate within the small claims court framework. Specifically, interpleader matters, for example, that at present could only be heard in the High Court, could now be held and heard in this small claims court. It is updating offences relating to assault, obstruction, rescue of goods from bailiff to reflect enforcement under the small claims court, to provide mechanisms for dealing with misconduct by bailiffs under supervision of a small claims court judge, regulate actions against bailiff. The Summary Courts Act, Chapter 420, there will be consequential amendments seeking to insert a statutory definition of the small claims matter by reference to the Civil Division Act 2026 and the Criminal Division and District Criminal and Traffic Courts Act 2018 will expand the Chief Justice administrative powers. Mr. Speaker, the Civil Division Bill 2026 is a critical step in the justice sector reform and improvement of service delivery in the administration of justice in Trinidad and Tobago. This modernization process and push by this government, Mr. Speaker, does not end there. I would give you a bit of disturbing news when we assumed office. I had conversations with the Forensic Science Center, with the director of the Forensic Science Center, Mr. Speaker. And when we assumed office, I was horrified to learn. 3,000 autopsies reports were not completed. Mr. Speaker, you had a stellar career in the Criminal Justice Department, as my learned friend Porter Spins out. When you do not have these autopsy reports, what happens to the criminal justice system? It grinds to a halt. Judges might be prepared. Defense counsel might be prepared. You don't have your report. The case can't go on. It gets adjourned indefinitely. One aspect, one cog in the wheel of the criminal justice system. You have bailiffs, you have police, you have prisons, you have forensic science center, availability of judges, availability of defense counsel. But that important function, 3,000 reports. Immediately, Mr. Speaker, immediately we recruited 4 House officers to work with the forensic pathologists at the Forensic Science Center. Within a few months, we were able to remove 300 reports from that list, Mr. Speaker. And I'm pleased to report that the list for 2025 and 2026, all reports for those years, have been completed. We are now working to clear that backlog over the years. We want the criminal justice system to work. We want to deliver justice. People must not be frustrated. People must not only have access to justice, they must see it working for them. We have also included in the biology department, we have recruited 6 DNA persons with DNA experience to work in the labs to help us upgrade our DNA, which is a huge backlog as well, Mr. Speaker. So, Mr. Speaker, on all fronts, whether it's forensic, reform of laws, reform of our small claims court, mobile units in the legal aid, Mr. Speaker, everything is being refreshed. Everything is being modernized. Everything is being brought up to date. What a great time for Trinidad and Tobago. Mr. Speaker, we must continue to be optimistic because we know that Trinidad and Tobago is going to get better. And Mr. Speaker, with those few words, I beg to move.
Honourable members, we are just 3 minutes beyond the tea break, but the honourable member had 3 more minutes of his time. But what I propose to do is read the question for debate, and then we take the tea break. Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Make Jurisdiction for Matters of a Civil Nature exercisable in a division of the judiciary to be known as the Civil Division, and to make jurisdiction for specified civil matters exercisable in a subdivision of the Civil Division known as the Civil Court, to make jurisdiction for small valued claims exercisable in a subdivision of the Civil Division to be known as the Small Claims Courts, and to make jurisdictions for estate administration business exercisable in a subdivision of the Civil Division known as the Estate Administration Office, and for related matters be now read a second time. So I propose to take the tea break, and I think members will agree with me. We have a long night ahead of us. I propose to come back at 5:30. 5:30 instead of 5:15. I propose to come back at 5:30, unless there is 5:30. Yes. So, because I foresee we have some distance to go. So this House is now suspended. We come back at 5:30. Thank you.